All right. Again, welcome to our Technical Friday. We have a few logistics as we start. So this webinar is being recorded. If you have any questions, please use the question and answer feature on Zoom. And then we have some specific logistics for attorneys. We have applied to provide continuing legal education credits for this course. We will provide a code on the presentation at some point during today. Please write that down. We will be sending a verification form, which you will have to complete and send back. Once we do get approval to provide CLE credits, we will send you your certificate of attendance. So please keep that in mind and keep watching. We always start our programs with a land acknowledgement. We recognize that the land and water now under our care is the traditional and ancestral territory of the Lenni Lenape. We pay respect to the Lenape peoples, past, present, and future, and their continuing presence in the homeland and throughout the Lenape diaspora. We respect their knowledge, culture, and tradition, which have contributed to the conservation of land and water. So we have a great program. We have a great program, and here's sort of the agenda. So we'll go through. We're going to mostly take our questions at the end, but if there are questions that pop up in the Q&A, so again, please use that Q&A function of Zoom. I may jump in and interrupt one of our speakers to get that question answered, but most of them we will wait to the end. We have a bio, so our presenters are the Eastern Environmental Law Center. I always say clinic, but it's the center. Attorneys who represent nonprofits, environmental organizations in New Jersey. I've had the pleasure of working with them on multiple things over the last several years. We have Chris Miller, who's the executive director. We have William Bittinger, who's a staff attorney. And I keep going too fast, and Daniel Greenhouse and Maggie Broughton, all of ELC, so they will all take portions of this. Again, I appreciate everyone's attendance, and now I'm going to turn it over to you, Chris.
Great, thanks, Mike, and thanks to the Watershed Institute for inviting us to speak on this topic and for hosting the webinar. And thanks to everybody in attendance today for taking time out of their Friday to be with us. This webinar, covers material that really gets to the heart of what we at EELC do. We're New Jersey's public interest environmental law firm. And as Mike said, we represent environmental groups, community groups, citizen groups, and help them use the legal tools that we have available to assist with environmental advocacy efforts. So I'm going to try to share my screen and hopefully don't run into any technical issues on this Technical Friday. All right, hopefully you can see this.
Yeah.
Great. All right. I'll be presenting, giving an overview of New Jersey's environmental citizen suit law, which is the Environmental Rights Act. This is an important legal tool in the toolbox for environmental litigation. It's probably the most important reason that it's such a valuable tool is that it can help reduce standing issues. A lot of times, with environmental litigation, private groups can run into standing issues. The Environmental Rights Act is clearly intended to be an environmental citizen suit law. So I'm going to cover the historical context of the statute, the legislative intent of this statute, the specific cause of action that it creates, the limitations and the scope of that cause of action, some of the procedural aspects of the statute, and I'll end by covering the attorney's fee provisions of the statute there. So To kick this off, I'd like to just put the statute in historical context. And as we know, by the 1960s, New Jersey, and many places in the US, were dealing with industrialization, increasing development in the post-war years. And with that, obviously, came widespread air and water pollution and increased pressure on our environmentally sensitive areas. And so the Environmental Rights Act was adopted in 1974, which is sort of part of the golden era of environmental legislation, when our legislatures were recognizing this problem and came together to act to provide a remedy. So this timeline I've sort of put together tries to place the Environmental Rights Act within that context. And fun fact I discovered in preparing this, the Watershed Institute's predecessor association, which I believe is the Stony Brook and Millstone Watershed Association, was founded in 1949. So much earlier than many of our environmental statutes. So, as I mentioned, legislatures, both at the federal level and state levels, were coming together during that golden era to address, the widespread environmental contamination that we were facing. And with respect to the Environmental Rights Act in particular, the legislature spoke very clearly in adopting this statute. And I think, as you can see with this quote, the breadth and the clarity of this legislative intent is really striking. The legislature is finding and determining that the integrity of the state's environment is continually threatened by pollution, that every person has a substantial interest in minimizing this condition, and that it's in the public interest to enable ready access to the courts for the remedy of such abuses. So couldn't be more clear that the intent of the Environmental Rights Act is to authorize citizen suits to enforce our environmental laws, and really to open the courthouse doors for private groups and private citizens to sort of act like private attorney generals in enforcing environmental law. It should also be noted that the legislature specifically directed the courts to liberally construe the ERA to carry out this intent. So if there's a question of construction or some ambiguity in the law, the legislature has spoken and directed the courts to resolve such questions in favor of the intent of the ERA, which is to protect the environment. Moving on to the cause of action, the Environmental Rights Act has two sections which really are the meat of the statute, which explain what it is that private citizens are authorized to do. Section 4A, which I've quoted here, is pretty straightforward. Any person can commence a civil action against any other person, which includes government entities or corporations, business entities, that have violated any statute, regulation, or ordinance. So this includes municipalities and local laws, which are designed to protect the environment. The remedies available are limited to injunctive relief. So, money damages are not available. And the cause of action requires that you allege basically an ongoing environmental violation, or a violation that's recurring and likely to recur in the future. So this part of the cause of action is pretty clear, that it's Section 4A. Section 4B is a little less clear. I think it's an example of inartful drafting. And the reason I say that is, as you see here, like in the beginning of the provision, it says, except in those instances where the conduct complained of constitutes a violation of a statute, regulation, or ordinance, which establishes a more specific standard for the control of pollution, etc., any person may commence a civil action in any court of competent jurisdiction for declaratory and equitable relief. So when you read this, it sort of leaves open a more specific standard than what? It's sort of confusing the way it's written. But I mean, this provision has been interpreted by the courts. And I've sort of bulleted out here, what these two provisions are distilled to mean. And that is essentially that the ERA gives private citizens groups a cause of action to enforce a specific environmental statute, regulation, or ordinance, or if there is no specific standard set forth in a statute, then you essentially have a public nuisance claim. You can bring an action under the ERA for protection of the environment or the interest of the public therein from pollution, impairment, or destruction. So Section 4A and Section 4B are at the heart of the statute. These are the citizen suit provisions of the ERA. Now, the ERA doesn't itself provide a substantive cause of action. What does that mean? So when you file an ERA complaint, you are not alleging that a corporation or a business has violated the ERA. The ERA is used to enforce separate environmental statutes. So you would use the ERA to claim that an entity has violated, for example, the Spill Act, the Solid Waste Management Act, the Water Pollution Control Act, or others. And again, the available remedies for private citizens are injunctive, declaratory, and equitable relief. So I'm going to try to get through some of the case law that interprets the ERA here. In particular, what is the scope of the cause of action under the ERA? The ERA grants groups standing to enforce environmental protection laws not only as an alternative to inaction by DEP, so in those instances where DEP has totally failed to enforce, but also it's important to note that the ERA can be used where DEP has inadequately enforced environmental laws. So not just where DEP has ignored a violation, but where DEP has even taken some action, but perhaps not the fullest extent of enforcement action allowed under the law. So this is a little bit of a gray area under the statute. When you file an ERA action where DEP has taken some enforcement action, unfortunately, we don't have a bright line test about what level of DEP action, enforcement action, is going to preclude an ERA claim from going forward. But we do have some cases which give some examples of how the courts have interpreted this. So in the case Player v. Motiva Enterprises, which is a district court case from 2006, the court dismissed an ERA claim for enforcement of the Spill Act, where it was clear that DEP had engaged in consistent and pervasive oversight of remediation efforts. DEP required the defendant to regularly test wells and institute groundwater recovery systems. In Morris County Transfer Station, it's an appellate division case from 1992, the court upheld an ERA claim to enforce the Solid Waste Management Act, where the defendant was still operating an illegal facility 2 months after DEP had issued a notice of violation, and yet DEP had taken no further enforcement measures. So there's an example of inadequate enforcement. In the next case, Port of Monmouth Development Corporation, summary judgment was granted on an ERA claim for landfill closure, where DEP had been making enforcement overtures for 12 years, but ultimately stopped short of taking any concrete legal enforcement action. And then I think in the most striking case, this most striking example, Howell Township v. Waste Disposal Incorporated, we have the court reversing dismissal of an ERA claim for landfill closure and remanding to the agency for fact-finding, even where DEP had conducted a compliance review and determined that the defendant had failed to meet the compliance dates and administrative consent orders, that DEP had intervened in the action, and that DEP and the defendant had entered into a partial settlement. So this is not an example of DEP sitting on its hands, and yet the court is allowing the ERA claim to go forward. The plaintiff in an ERA case needs to allege either continuous or an intermittent violation of environmental statute. So this is not intended to address purely past environmental violations. The ERA is intended to address existing and future violations, ones that are likely to recur. An example of this was in the Flint Coat case, which is a district court reviewing a bankruptcy decision that touched on the ERA. And in that case, a private party sought to enforce the Environmental Rights Act against the debtor of property that was contaminated, where the debtor had sold the property decades before. And the court there said, no, the Environmental Rights Act is really designed to address ongoing violations. Here, the debtor sold the property long ago, so the ERA claim is not going to come forward. And as I mentioned earlier, the remedies available to private citizens are limited to injunctive or other equitable relief. In the DEP v. ExxonMobil case, which dealt with the NRD settlement, a group of environmental nonprofits sought to intervene to review DEP's settlement with Exxon. And the intervention complaint sought to recover natural resource damages under the Spill Act. And the appellate division affirmed the denial of intervention because the ERA doesn't authorize the recovery because the Spill Act doesn't authorize recovery of NRD by a private citizen. The ERA couldn't be used to do that either. And this is, again, getting back to that ambiguity I noted earlier in section 4B. Here, I've tried to give a couple examples of how the courts have tried to make sense of that language. So in Raritan Baykeeper v. NL Industries, which is a Third Circuit case from 2011, the plaintiff's case was dismissed where the plaintiff was seeking enforcement of RCRA, Resource Conservation and Recovery Act, and Clean Water Act standards. And the court said, well, no, the ERA doesn't authorize a state court to enforce rights under RCRA and the Clean Water Act. So that case was dismissed. And then in a case which was really puzzling to me, again, I think the court was sort of trying to bend over backwards to make sense of this more specific standard language in the statute. A borough was trying to challenge the New Jersey Department of Transportation's widening of the parkway based on air, noise, and drainage impacts. And the court said that claim couldn't go forward because DOT had conducted some studies in accordance with what was called the New Jersey Action Plan. And the court said, well, that plan established more specific standards for the control of pollution, and therefore the ERA claim was not allowed to go forward. So notwithstanding this sort of ambiguity in section 4B, where there's a violation of a state statute, a state environmental statute, it's very clear that the ERA can be used to enforce that. Where some of this ambiguity and some of the confusion in the case law comes from is really attempts to enforce non-state laws, for example, RCRA and Clean Water Act, and this sort of unique case with DOT and the Parkway wide. Now, the procedural requirements are really important. 30 days notice is required to the Attorney General, the DEP, and the governing body of the municipality where the violation occurs, as well as the intended defendant. The case will be dismissed if that procedural requirement is not met. So that needs to be adhered to. There is a possibility that the court will waive that notice requirement if you can show immediate and irreparable damage will probably result. The ERA allows courts to basically remand a ERA case back to DEP or whatever governmental entity is, has proper jurisdiction for administrative proceedings. And we were involved in a case recently where this happened, which we sort of view as a positive outcome. Even where the court has decided not to adjudicate the claim, but still, remits it back to the administrative agency, it's nice to have the judicial oversight over those proceedings, and the court is statutorily required to retain jurisdiction. In doing so, the court can grant temporary equitable relief if necessary to protect the environment. And finally, I'll conclude on the attorney's fee provisions. Attorney's fees in New Jersey are generally not authorized unless by statute or contract. And here we have a specific statute authorizing attorney's fees. They are available to a prevailing party that's had reasonable success on the merits. If that's an action against the government, you're limited to recovering $50,000. If the case is resolved by settlement, there's judicial oversight of that settlement. And as you can see here, the settlement funds are limited to be used for environmental purposes. And the final note on attorney's fees is that they're not available if you are successfully challenging DEP's regulations. That was made clear in an adult division case from 1989. So I will wrap it up there. I think the takeaway is that the ERA is an important statute because it resolves some of the standing issues that environmental litigants often face. We have a clear statement of legislative intent to open the courts to private citizens to enforce environmental laws, and this should be something that attorneys and potential clients consider when they think that DEP, for example, isn't doing enough to enforce the law. Thanks.
Thanks, Chris. And I think, Dan, you're up next.
So hello, everyone. My name's Dan Greenhouse. If you haven't met me yet, I'm a senior staff attorney at Eastern Environmental Law Center, and I'm going to discuss how to challenge a permit decision by DEP. Now, let me start by saying that DEP does so many different things. And Chris really delved into an opportunity to challenge DEP's action or inaction when there's violation of law under the Environmental Rights Act. DEP enters settlement agreements, all kinds of other agreements with other different agencies or areas of the government, local level, county level, regional governmental entities. DEP uses its enforcement discretion to either take enforcement actions or not take enforcement actions. DEP promulgates rules and regulations. DEP makes funding decisions and more, right? So it does all of these things. But what I'm going to focus on is when DEP makes a permit decision. And in that case, it's a very discrete final agency action. And in response to a permit decision by DEP, you have a few options in terms of trying to challenge that permit decision. And so there is some well-tread ground in terms of challenging a permit decision, and there are also some questions and vagaries here, which I'd like to discuss with you. So from a practitioner's perspective, let's start with the Administrative Procedure Act, which is really the law or the state of the law as it's set forth in statute for what is a permit decision and what the response might be. So let's just first start. I hope you can see here what the definition of a permit decision is under the Administrative Procedure Act. And here, this definition is extremely broad, right? We have permit decision means a decision by a state agency to grant, deny, modify, suspend, or revoke any late agency license, permit, certificate, approval, chapter registration, or other form of permission required by law. And then there's an exception after that. But really what we're looking at here is the most broadest of definition, the most broadest of terms in defining what a permit decision is. So when DEP makes a permit decision or is in the permit decision-making process, the Administrative Procedure Act here, we're going back up to the first slide, provides that all interested persons are afforded reasonable opportunity to submit data, views, or arguments orally or in writing during any proceedings involving a permit decision. So this is the first step when you want to challenge a permit decision, or you want to persuade DEP to act a certain way in regard to its permit decision-making process. You need to get involved with DEP by submitting what is called a public comment, right? Usually these are written, sometimes there are public hearings, depends upon the statutory framework at play, whether it's water, land use, air, and whether anyone has requested a public hearing so that they could submit oral public comments. But for the most part, in this technological era, we're able to submit public comments by email. And as attorneys, we review DEP's bulletin and for notification that DEP is in the permit decision making process so that we can hit that public comment period. The public comment period is usually pretty narrow. So in terms of reviewing what's been submitted as a permit application and then making a comment about it, you do have to pay attention to that public comment period deadline. Now, I'd like, before we move on to what an administrative hearing is, or requesting an administrative hearing to challenge a permit decision, I want to give you a few case studies that will help bring this into focus. And I don't have slides, so I hope you can just follow along with me. In one situation, we have, for example, the Skylands Preservation Alliance wanted to challenge a Flood Hazard Area Control Act determination. And so we filed a request for an administrative hearing and also sought judicial review at the same time, right? So there are these two avenues that we went down to challenge DEP's permit decision: the judicial branch and the executive branch agency. And remember from your civics class in high school, we have the judicial branch, the legislative branch, and the executive branch in our state government. And so when you request an administrative hearing, what you're doing is you're requesting an administrative hearing before the Office of Administrative Law, which is an executive branch agency. It's not exactly a real judge, right? But we're not going to call them fake judges. They are administrative law judges. They're just in the executive branch. The real judges are in the judicial branch. So when we filed, in that case, both a request for an administrative hearing and sought judicial review, the appellate division said your notice of appeal in the appellate division is premature. Wait for you to go first at the administrative hearing level. So I want you to remember that, because after I go through a few of these slides, we're going to come back to that case study and kind of try to dissect why the court said that and whether that was an appropriate response by the court. So what we have here in this slide, maybe I need to zoom in a little bit more, or hopefully you can read that. I'm centering the slide that I'm reading from. But prior to 1978, most contested cases before state agencies were initially heard by hearing examiners, many of whom were employees of the very agencies responsible for deciding the controversies. So you could imagine if you did have a controversy with DEP and you requested an administrative hearing and you went to DEP and it was an employee of DEP who was the hearing examiner and the decider of the controversy, that you might feel as if it wasn't so objective or fair, because the DEP is governing the proceeding or the administrative hearing. So in order to resolve that sense of impartiality or unfairness, the legislature created the Office of Administrative Law and administrative law judges who work at the Office of Administrative Law to be impartial and objective hearing examiners. And this is from this case back in 1982, where some of the first rules governing the administrative hearing procedures were being challenged. And so here we have a very concise statement about the regulatory power exercised by administrative agencies, including administrative law judges. It's a legislative, executive, as well as judicial in terms of the attributes. It's called quasi-judicial, or characterized in legal terminology as quasi-judicial. Like I said, it's not exactly in the judicial branch, but because the legislature has delegated certain authorities to executive branch agencies, they do make these determinations, these permit decisions, which are characterized as quasi-judicial determinations because there are findings of fact and applications of law associated with them. So when somebody requests an administrative hearing before an administrative law judge, that's called a contested case. And it's commenced in the state agency with appropriate subject matter jurisdiction. So in this case, if the Department of Environmental Protection makes a permit decision, the request for an administrative hearing would be made to the Department of Environmental Protection. And then if the Department of Environmental Protection grants, denies that hearing request, it would be transferred over to the Office of Administrative Law for an administrative hearing. Now, here, I just wanted to give you a slide with all of the subchapters, or basically the table of contents of the Uniform Administrative Procedure Rules. So you got a sense of what we were playing with here. The Uniform Administrative Procedure Rule sets out in pretty good detail what an administrative hearing is going to consist of and how it's going to be conducted. There are nuances here that I'm not going to spend too much time on, but you do have parties, you have the commencement of the case, very much like a pleading in the judicial branch, very much like a complaint. It's the hearing request, and then you have the representation and the parties and the pleadings and all of the discovery and pre-hearing conferences, and then the trial itself. You have allowances for intervention and participation. And then what you have is you have the requirement that an administrative law judge will issue an initial decision, and then the commissioner gets to issue a final decision after that. The administrative law judge issues what's really a recommendation to the commissioner of DEP. So again, has the creation of the Office of Administrative Law and administrative law judges really created an impartial or objective hearing officer? Or, are we still back at square one before 1978, where you have this sense that you're walking into DEP to decide a controversy that you have with one of DEP's permitting decisions? That kind of remains to be seen, and I think it's on a case-by-case basis. But for example, one of the things that's different about an administrative hearing is the evidence rules. In the Office of Administrative Law, before an administrative law judge, you have what's called the residuum rule, which is that evidence, you don't have to comply strictly with the rules of evidence. So in New Jersey, the rules of evidence is a thick book of fine print with regard to what can be or cannot be admissible in a court of law in the judicial branch. But in the Office of Administrative Law, you don't have to comply strictly with those rules of evidence. You can stray as long as there is a residuum of credibility with regard to the evidence that you're presenting. So in the Office of Administrative Law, you get a little bit more leeway in terms of presenting evidence, and the administrative law judge will take more into account. So all of those objections you hear when you watch TV about the admissibility of evidence, that doesn't happen so often in the administrative law context. In an administrative hearing, you have to be a little bit more flexible. So at the end of an administrative hearing, the commissioner gets to issue a final decision. And again, here I'm jumping into the judicial rules. Now this slide sets forth the New Jersey court rules to review final decisions. So the administrative process doesn't reach a culmination to a final decision until the commissioner gets the final word. And appeals may be taken to the appellate division as of right to review final agency decisions or actions of any state administrative agency. Except, and again, I underline this last part of this paragraph because it's very important, except that review pursuant to the subparagraph shall not be maintainable so long as there is available a right of review before any administrative agency or officer unless the interest of justice requires otherwise. So what does that mean, that you can file an appeal with the appellate division as of right, except unless there's available a right of review before an administrative agency or officer? That generally means that you have to exhaust your administrative remedies first. And what that exhaustion of administrative remedies requires is that if you do have an avenue of relief before the administrative agency itself, you do have to go and take that. Now, in order to request an administrative hearing to challenge a permit decision, you have to do so within a specific time frame, usually 30 or 35 days from when the permit decision was issued or publicly noticed. So after that time frame, you no longer have an avenue for administrative review. So if you only file a notice of appeal to the appellate division, and that 30 to 35 day time frame to file an administrative hearing request has passed, then you can claim that there are no further administrative remedies or avenues for administrative review to exhaust. And so that might be a reason, or the reason, why you would not request an administrative hearing. You have 45 days from the date of service of the decision itself, or the notice of the action, to file a notice of appeal with the court. This is a citation from a case that says that an agency action does not become final until all avenues of internal administrative review have been exhausted. And that an indicia of final agency action is whether a decision is subject to further review within the agency, including review by the commissioner, or whether the matter has been referred to the OAL for further action. So in another case I'm handling, this is for the Musconetcong Watershed Association. There was a Department of Environmental Protection issued a decision, a permit decision in 2017. The Musconetcong Watershed Association requested an administrative hearing and did not seek judicial review. 4 years later, DEP finally decided to deny the administrative hearing request, but objected when we tried to appeal the underlying agency decision along with the denial of the administrative hearing request. Now, you would think that because the courts have so clearly enunciated this exhaustion of administrative remedies requirement, that the Musconetcong Watershed Association was proper and correct in waiting to seek judicial review of the permit decision until DEP had denied its administrative hearing request, being an avenue of potential administrative remedy or further review within the agency. But the court did not really buy that argument. So DEP's position is at this point in time that if you file a request for an administrative hearing, that does not toll the time, the 45-day time frame for you to file a notice of appeal in the appellate division. You would think that requesting an administrative hearing would put your foot in the door in terms of filing in a notice of appeal to challenge the same underlying agency decision at some later date when DEP finally did deny or grant your administrative hearing request, but that is not the case. So beware. And I'm telling you that now, that the best option is to file a notice of appeal with the judiciary, even if you have also filed an administrative hearing request. So the next thing that happens after you file a notice of appeal is that the agency has to file within 30 days of the service upon it of the notice of appeal, a statement of items in the record. So sometimes we file an appeal with the appellate division, and then we wait for months and months. DEP rarely, and the Division of Law in the Attorney General's office, DEP and the Attorney General's office rarely, if ever, meets this 30 days requirement to file a statement of items comprising the record. When you have an appeal pending, the time schedule of that appeal may be accelerated on the court's own motion or on the motion of the party. So you could seek an accelerated appeal if you have good reasons to. It's rarely, if ever, granted. I'm not sure if there is any clear, bright line about what the court standard is for accelerating the schedule of an appeal. Appeals at this time are taking a very long time to move forward. Like I said, DEP doesn't comply with this 30-day requirement. It's usually months before you even see the statement of items comprising the record. It could even be 6 months to a year. So you file your notice of appeal and then nothing happens. Everything slows down. Can you accelerate it? Possibly, if you have good reasons. And again, if you needed stay or an emergency order or temporary relief, you can apply to the appellate division for such relief. But again, the legal standard for meeting or requiring an emergency order is very high. There has to literally be a fire that needs to be put out. There needs to be some danger and imminent harm being posed to somebody who is a party. You cannot just seek the emergency relief because it's taking too long in court, or you're frustrated with the amount of time that the appeal is taking. And then I just put this slide here to give you an idea of how detailed and how much time it takes to put together the briefs for an appeal. It is not just a few-page letter or a motion to court that you might have seen in other circumstances. It's not just factual pleadings. You need to put everything in fine detail in your brief, and there's a 65-page limit. And I'm telling you, I've rarely seen the case where that 65-page limit isn't hampering the attorney's ability to say everything the attorney wants to. Usually it's a leash that you try to stay cognizant of while you're writing it. You need to have a table of contents, table of citations to cases, table of judgments, procedural history, statement of facts, and then your legal argument. And most attorneys, I like to avail ourselves of the opportunity for a preliminary statement not to be longer than 3 pages, so that you can give an executive summary up front in your brief. And then there's the appellant's brief, and then the respondent gets to submit a brief, and then you get an opportunity to reply. So there's an exhaustive briefing schedule. You get to request oral argument. Here is the court rule cited for that. You have to request oral argument in a very tight time frame within 14 days after service of the respondent's brief. And then the court usually grants oral argument. But again, this is not an expedited process. You go through the briefing schedule. It might take a year or more to go through the briefing schedule, and then it might take a year or more before you have oral argument. So requesting oral argument is another question or legal strategic decision that must be weighed carefully and calculated very carefully, because when you request oral argument, you have to ask whether you're advancing the opportunities or the interests of the parties, because it is going to take so much longer to get it on the schedule and then decide it. So if you do request oral argument, you have to wonder, well, what issues do I need to enlighten the court about, or is this going to help us or hurt us because of the amount of time it's going to take and the opportunities to stand before the judge and potentially get peppered with questions by the judges about various different things. So again, another legal strategic decision, not just what arguments to present or what angles to take or what the core theory of the case might be, but whether you think that oral advocacy will help the case. So here on this last slide, and I'll wrap it up, I want to be cognizant of the time here, but I think that the major question you need to ask, or that, you know, we face as legal practitioners when potential clients come to us, or clients come to us, is, should I file a request for an administrative hearing? Okay, I see this permit decision by DEP. I don't like it for some reason. Should I file an administrative hearing request, or should I file a notice of appeal in the appellate division, or maybe both? And again, it's very difficult to pick this apart, right? And in different circumstances, you might be under different statutory frameworks, you might be in different positions. Under the Water Pollution Control Act, somebody besides the party seeking the permit can get an adjudicatory hearing. So you might want to do that there. While in other statutory frameworks, there's no reason to request an administrative hearing if you're not the party that's applied for the permit, depending upon the factual circumstances. But there might also be some reasons that it would be helpful to have an administrative hearing before you go to court, and one of them is to build the requisite factual record. And if DEP hasn't done that, and you think that examining an expert or presenting evidence to DEP before an administrative law judge might help, again, that's probably something you need to discuss with your lawyer, and make a strategic legal decision. But the administrative hearings are less onerous. Like I said, the rules of evidence don't strictly apply, and they sometimes could be less expensive in terms of time and resources and money, you know, to engage DEP in an adjudicative process, or quasi adjudicative process. Okay, I'll end it there, and thank you very much. And I hope that I was clear, and if you have any questions, please feel free to email me directly or through Mike at the Watershed, and I can answer any further questions.
Thank you, Dan. And we did start a couple minutes late, so I think we're sort of right on time. Next up is amicus. Maggie and Will talk about that process. They're helping us through one already that they just recently argued a couple months ago. Will did for our category 1 support of DEP. But Maggie, Will, take it away.
Thank you. And yeah, it looks like Maggie's going to share our slides. So we'll be talking today, Maggie and I, about how to participate in judicial proceedings as an amicus curiae. Just a legal disclaimer, you know, we're just providing here legal information, not legal advice. So the relevant rule here, so I think this will be the next slide, is New Jersey Rule 113.9, and we've sort of highlighted the significant parts. An application for leave to appear as amicus curiae in any court shall be made by motion in the cause, stating with specificity the identity of the applicant, the issue intended to be addressed, the nature of the public interest therein, and the nature of the applicant's special interest, involvement, or expertise in respect thereof. And there's more language there, but that's sort of the heart and soul of it. I would also add, in terms of timing, further down in that rule, it says, except in a certain circumstance, motions for leave to appear as an amicus curiae in the appellate division shall be accompanied by the proposed amicus curiae brief and shall be filed on or before the day when the last brief is due from any party. So that's an important timing thing to think about. So overall, right there, you have the foreign-made substantive requirements for a motion for leave to appear as amicus curiae. 1, identifying the applicant. 2, discussing the issue intended to be addressed. 3, the nature of the public interest in those that issue or issues. And then 4th, the nature of the applicant's special interest, involvement, or expertise in those issues. So Maggie and I are going to go through each of those 4 requirements more in depth from the perspective of the amicus briefs we've dealt with at ELC to give you some more context. But first, we're just going to give you an overview of each of the sort of amicus briefs that we've dealt with. So my multiple ones I've dealt with, one we call Fairways. It was in the Superior Court of New Jersey Law Division. The client was Save Barnegat Bay, which is a nonprofit conservation organization with a mission to protect water quality, conserve open space within the Barnegat Bay watershed. And the overall case involved the conversion of the Fairways golf course from open space to dense residential housing. The second case I've dealt with, we call Dock Road. The client again was Save Barnegat Bay. And this case was in the appellate division. And overall, it would involve the Environment New Jersey, the New Jersey Conservation Foundation, and 8 nearby homeowners challenging DEP's decisions to approve a confined disposal facility, or CDF, for storage of dredge material near the Barnegat Bay's edge. The third case I've dealt with, we call the C1 upgrades. Mike mentioned that. This is the clients were the Watershed Institute, also the Raritan Headwaters Association, and New Jersey Highlands Coalition, nonprofit environmental organizations with missions to protect, enhance, and restore water quality and natural resources within New Jersey. And that's in the appellate division, and involves challenges to DP's April 2020 C1 upgrades. This is an upgrade by New Jersey DEP, amending the surface water quality standards, upgrading approximately 600 river miles to a C1 anti-degradation designation. And then the fourth matter I've dealt with an amicus, the client was New Jersey chapter of the Sierra Club, which is a national member-supported environmental organization which advocates for clean air, clean water, and protection of public health. This was in the appellate division, and this is from Pineland Preservation Alliance's a revised initial brief. They were appealing from the final decision of the New Jersey Pinelands Commission, rejecting a resolution and failing to take final action to revoke the Commission's prior approval of a South Jersey Gas proposed natural gas pipeline project through the Pinelands area. So I'll stop there so Maggie can discuss her experience with amicus briefs.
Thanks, Will. I only have one experience with an amicus brief, but it was regarding a facility in Camden, specifically in the neighborhood of Bergen Square. It is a toxic waste dump storing construction and demolition debris that has been contaminated by PAHs and toxic metals. My client in that case was Workforce and Economic Revitalization for Communities, which is a 501c3 nonprofit. And in that case, we were advocating for the quick and responsible cleanup of that site. It still remains to this day and is negatively impacting the community of Bergen Square, which is an overburdened community under New Jersey's environmental justice law. So I'm going to turn it back to Will so he can talk about some of the other elements and how they specifically play out in amicus briefs.
Thanks, Maggie. And maybe let's go to the next slide. I think it has the 4. Yes, you can have these 4 main requirements in front of you. And before I go into them, I just want to say, in terms of mechanics, you'll be submitting to the court a motion for leave to appear as amicus curiae, along with the proposed amicus brief that's required in the appellate division and Supreme Court. But there's no one size fits all approach, but what I've seen in successful motions is that the motion and proposed brief are also accompanied by a certification by someone affiliated with the client, which is the proposed amicus. So that would be, for example, the executive director of a nonprofit environmental organization. And then that certification in general speaks to each of these 4 requirements we've listed from the rule. But the proposed brief is where the issues, so that's, that second requirement, that's where the issue should really be fleshed out in detail. And so that, first requirement, identity of the applicant, we basically kind of through giving you these cases we've been a part of, already ran through that. So you kind of already got the first requirement. I gave you some flavor for each of the clients we were working with in those matters. And I would just say when describing the applicant, meaning the proposed amicus, keep in mind the applicant's special interest, involvement, or expertise that you'll be discussing. If Maggie wants to add anything on that point, I'll turn it over to her.
Sure. I just wanted to mention one thing specifically about my case, is that a lot of Will's amicus briefs involved clients who were environmental nonprofits or had specific environmental interests, and the organization I dealt with, Workforce and Economic Revitalization for Communities, was a 501c3 nonprofit, but does not focus on environmental issues, but instead their mission is to revitalize the community of Camden, make them economically self-sufficient, and to empower individual residents and local businesses. So it's not necessary that, my client had specific experience working on EJ cases or had specific experience working on environmental issues, but that the special interest can kind of be predicated on something different, like experience with the community and wanting to revitalize that community. So back to you, Will.
Thanks, Maggie. So I'll move on, actually skipping down to, in the rule, the fourth requirement, the applicant's special interest, involvement, expertise. But back to kind of mechanics process, I would actually start by focusing on this requirement just in terms of internal process. Think about what you, if you're the proposed amicus, or your client can speak to based on their interest and background. I would say, even though it says special interest, involvement, or expertise, they should really sync up together. It's kind of, if you have a special interest, ideally, you have involvement or expertise that explains why you have that special interest. Just to give you a sort of more context, oftentimes in the environmental group, your special interest, involvement, or expertise won't be a pure issue of law like statutory interpretation. That's something you might see, for example, at the US Supreme Court, an amicus brief by, let's say, the ACLU, discussing the jurisprudence, sort of the way the First Amendment has been interpreted maybe in different federal circuit courts in the US. Environmental groups oftentimes don't have lawyers on staff. Even if they hire a lawyer, the lawyer can't be the one saying like, oh, well, I know everything, I bring a special interest, involvement, expertise. No, it's the proposed amicus. So what do they have to say, and why, what is what they have to say based on? It should be based on their involvement or expertise. And oftentimes that expertise is in the environmental impact of the case. I would say try to get yourself, the client, to think about this requirement as early in the process as possible. Don't wait until a few weeks before that amicus brief is due. Remember, I mentioned the deadline. And as mentioned above, you should include a certification from at least one individual with a proposed amicus who can speak to the special interest, involvement, or expertise in the issues you ultimately settle on. I would really hammer home the involvement or expertise in that certification. That's where you can spend a lot of acreage in pages talking about the involvement or expertise, whereas in the brief, you can really be focusing more on like the actual issues that you want to address, more of the arguments. And you can phrase it as, for example, proposed amicus X has a special interest in this matter pursuant to the rule because, and then you just list the two issues. So again, your special interest, in my experience, is kind of the issues you raise. It's kind of one and the same. But you first think like, what do we have a background or interest in? So I'll try to quickly give you some flavor from the cases I've been involved with of how we describe the special interest. So in that Fairways case, the golf course, say Barnegat Bay has a special interest in this matter because the conversion of the Fairways golf course from open space to dense residential housing would compromise the ecological integrity and useful functions of local water bodies in the Barnegat Bay and set a negative precedent for other existing open spaces in the Barnegat Bay watershed. I'll go to one other one, South Jersey Gas, in mindful time. New Jersey Sierra Club has an interest in ensuring that the Pinelands Commission follows the law and administers the comprehensive management plan in the public interest. So those are just some examples. And we went on to say, thus, the New Jersey Sierra Club has a special interest in this matter because the Pineland Commission's failure to disapprove the South Jersey Gas pipeline violates the Pineland Commission's obligations under the Pineland laws. So we'll stop there if Maggie wants to talk a bit about this requirement 4 in her experience.
Sure. So, like I said earlier on, in this case, my client wasn't an environmental nonprofit, but rather one focused on economic revitalization of Camden. So their special interest is a little bit different from the cases that Will is talking about, because they gained their experience by direct outreach and other experiences with the community and with the residents of Bergen Square. For example, they facilitated town meetings specifically on the issue of this contaminated waste site. They did surveys in the community of, what would they want to see the site turned into once it's cleaned up. I think they talked about green space, creating a public park or a community garden out of it. And they also engage in a lot of other activities to economically revitalize the community, including small business loans, classes on home ownership and credit counseling. So kind of a non-traditional environmental amicus brief. And that they had this special interest because this toxic waste dump was negatively impacting the community members, and cleaning it up quickly and responsibly would lend itself to helping revitalize the community and benefiting the community in a way that people could then focus on other issues in their lives, working on their small business instead of worrying about the pollution emanating from this site, which was very significant. And as I mentioned, exposure to it causes potential cancer and organ damage risks. So I'll turn it back to Will to talk about some of the other elements.
Thanks. So now I'm going to go back to the second requirement, and yeah, trying to keep this quick. So this is really the meaty topic, the issue intended to be addressed. And like I said, this really springs from your special interest, involvement, or expertise. Try, if possible, to coordinate with the party you're more supportive of. You probably have a party you're trying to support in this case, even though as an amicus curiae, you're technically a friend of the court. You're not a interested party in the classic sense of a party in the proceeding. And you should coordinate with that party you're more supportive of to be sure you're not being duplicative of their briefs arguments. And you could see if they'll support you if there's any challenges that come up to your brief, and I'll try to get it through that somewhat quickly. You could be accused in your brief of improperly raising new issues that the parties themselves have not raised. You could also be accused of improperly relying on evidence outside the record. It seems like this would occur only in the appellate division or the Supreme Court versus the Superior Court. These types of challenges came up in 3 of the 4 amicus cases I've dealt with. And I would say overall, there's no uniform position by New Jersey courts in my experience, and my experience is in the Superior Court and the Appellate Court. So I'll try to go through a few of these to give you a sense. So in that Fairways case, Superior Court, our arguments were that the proposed action would compromise the ecological integrity and useful functions of local water bodies in the Barnegat Bay, and approval of the proposed action would set a negative precedent for other existing open spaces in the Barnegat Bay watershed. So we were challenged in that brief, and it is true that, as the opposition stated, as the opposition motion to our motion said, an amicus must accept the case before the court as presented by the parties and cannot raise issues not raised by the parties. And they claimed that our brief had added proposed issues to the litigation that are not presently before the court. But we submitted a reply brief that our client's proposed participation should be liberally construed, and its motion should be granted based upon the broad implications, that's a key phrase, raised by the issues in the first amended complaint in the matter. There were oral arguments held on our motion, and it was ultimately granted by the court, which accepted our entire brief. So we were challenged but successful. The C1 is very complicated. Mike's organization is a part of that. But an opposition motion was submitted that challenged our proposed brief for referencing items that were not part of the record on appeal and discussing an issue not raised by one of the challengers on appeal. And they cited the amicus rule. It says briefs filed by an amicus curiae in any court shall comply with all applicable rules. And another New Jersey court ruled that the record on appeal shall consist of all papers on file in the court or courts or agencies below, and basically characterized that as an appellate court's review is limited to consideration of evidentiary material in the record below. And again, that's why the Superior Court might have less of an issue with this, because it seems when you're in a reviewing court is where someone could claim you can't go outside the record. And they also talked about raising issues that weren't raised by the parties. Basically, we submitted a reply. There were a lot of filings between the party opposing us and us, and ultimately we were allowed by the court to submit a revised version of our amicus brief that included all the issues we'd originally raised, but removed all citations to items that the court did strike. It said about some of them, the documents, 46 documents, that they were outside the record. Our argument, it's nuanced. Our argument was that we were in this revised brief ultimately advancing the same or similar points as in the initial proposed brief, but without the support of the stricken items as evidence. So these were simply arguments, allegations. The court was free to accord the weight it deemed appropriate to those statements from us. So it ultimately, we were able to get a brief in there, but we had to make this change to the citations, so to not be referring to them, relying to them. And I'll also talk about South Jersey Gas, try to go quickly. We faced opposition there. The Pinelands Commission said that we're raising new issues, which are not on appeal, and sought to introduce documents which are not part of the record on appeal. Again, this was in the appellate division. And they referred specifically to the second point of our brief. And then the court did deny our motion, and it referred to the idea that we were raising issues not previously raised by the parties or relying on evidence not presented to the commission. We actually subsequently submitted a second motion to appear as amicus curiae and revised our proposed brief and basically struck this point 2 that was what the Pinelands Commission had pointed to. And we took it out, and the court actually granted our second motion. They did say our participation was limited to just the filing of that revised brief. So basically we couldn't participate in oral argument. And then finally, Dock Road, I wasn't part of drafting the original amicus brief, but it includes multiple items that were not in the record. This is in the appellate division, and it faced no opposition and was completely omitted, everything in it, including the non-record evidence. So like I said, no uniform approach. And I would just, I'll talk briefly about issue 3, unless Maggie has anything she wants to add on issue. I know we're pressed for time.
Yeah, no problem. I'll just speak really quickly about my experience. And it's similar to Will's final case or his final amicus brief that I, with the filing of this amicus brief that I did in Camden, didn't face any opposition by the defendants and was admitted by the court in its entirety, even though it included non-record evidence on some issues that weren't brought up in the complaint or other filings. So it really is inconsistent with how amicus briefs are opposed. And I'll turn it back to Will since we're running low on time.
Thanks, Maggie. Very briefly, that third requirement, nature of the public interest therein, given this audience, I would just say it's sort of you're sort of inherently complying with our requirement by being some sort of environmental group, but you should explicitly speak to this in your actual proposed amicus brief or that certification I mentioned. Speak to why the issues you're going to raise are in the public interest. Not too hard to do, given if you're an environmental group. You're not usually just out for some NIMBY, not in my backyard, self-interest purpose. It's you're thinking of something greater. My overall conclusion is that if you file, and sorry, Maggie, if you have anything on point 3, feel free to jump in.
Yeah, I'll just say really quickly that, again, even though my client wasn't an environmental group, there's still a great public interest in remediating toxic waste dumps and other toxic sites in overburdened communities to remedy the historic siting of polluting facilities in low-income, minority, and limited English proficiency communities. So there's a great public interest that's kind of outlined in the policy of New Jersey's environmental justice law. And this case fits really cleanly into that public policy. Back to you.
Thanks. And just final to sum up, I went through the nuances, especially around what issues you plan to raise. So just sort of speaking objectively from my experience, if you file a more plain, what I'll call plain vanilla proposed amicus brief, that seems like it'll be less likely to face opposition. But if you file what I guess you could call a more expansive proposed amicus brief, which, for example, raises issues that you could argue reflect the broad implications of the case, but maybe weren't explicitly raised by the parties, or if the brief contains non-record evidence that wasn't in the record below, this is in the appellate division or Supreme Court, it will face a higher odds of opposition. And it's up to you as a matter of legal strategy. What do you want to do? You have to be prepared, if you go with the latter approach, an expansive proposed brief, to possibly face opposition. And then do you want to spend the time trying to support your brief and get it, all of it or as much of it as possible, admitted by the court? So I'll stop there, and if Maggie has any final words to share.
No, I think that's everything. Thanks for outlining that so well, Will.
Sure thing. So that's it from Maggie and me on amicus curiae. I guess back to Mike and Q&A.
Great. Thank you very much, everyone. That was interesting. We did start a few minutes late, so we will continue for a few extra minutes for questions. So please put them in the question answer box, so to speak. I'm going to start off not so much with a question, but sort of an observation, because the C1 litigation was extremely interesting. One of the issues that sort of made this thing a lot more complicated is the opposition, the people challenging DEP C1 upgrades questioned the entire concept of using volunteer science to support decisions. Not in a million years would I have thought that was going to be an issue. So that really begs for for us as a community, as we are preparing comments to support or oppose regulations or permits, to really start thinking of where the weak points are, where the opposition will be challenging it, and then trying to bolster the record from the get-go. Like I said, I think if I had sat down and spent 10 years trying to figure out how to challenge the C1 upgrade, I never would have thought of challenging the underlying concept of using citizen science or volunteer monitoring, since it is so well established in New Jersey and in many places in the country, but really start to think about that. So just sort of, I don't know if any of you have sort of thoughts, because when you're starting to challenge a permit or appeal, one appeal as an amicus, really your decision to do that may want to start from as you're submitting your comments. I don't know if any of you have thoughts or guides on how to sort of implement that.
Is that back to us as panelists?
Yes. Yes.
I would just say, yeah, it was more in retrospect with C1. We went over, it's hard to get into the nuance, but weren't able to explicitly rely on documents that weren't in the record. The court did strike examples of that. And so it's just sort of a fact. If those had been submitted, that material that we were seeking to cite at the appellate division judicial challenge level had been submitted in the record, presumably that can happen through someone submitting comments, you'd have the material that then you can then cite to later on, and you don't get into the sticky wicket. I still maintain it's a very nuanced point that in New Jersey, one can cite to non-record evidence as an amicus to be distinguished from a party at the appellate level. But you will avoid that issue. You can say, look, here it is in the record. So if you somehow know, so it does speak to, I said, even preparing early for your amicus brief, once you know that something's being challenged, but it's really even, as Mike's maybe kind of getting at, if you think there could be a challenge down the line to a proposed rule or anywhere where you could affect the record, get going and getting material into that record. It's only going to help you down the line.
All right. There was an earlier question that Chris, you answered, or maybe it was Dan, about using the Environmental Rights Act to challenge planning board decisions. I think your answer was probably not, but that's also an interesting concept. Land use boards are making lots of indirect environmental decisions, but they're not necessarily DEP permits or implementing environmental regulations. One may argue the land use boards are implementing the stormwater rules, and maybe there is a place to do it. Had never thought of that before. So I thought that was a very interesting question. It deserved to be sort of called out. Any thoughts about using the Environmental Rights Act in challenging a permit itself that gets the attorney's funding? I have not seen that, but any thoughts on that?
Yeah, I mean, the ERA really is designed, to address a violation of the law, of the environmental law. And a lot of the cases that we see, it's where DEP is just failing to enforce or really dragging their feet. So that, obviously that's a little bit different context than a permit violation. I think a case could be made. You could try challenging a permit under the ERA, but that's not the typical way that the ERA has been used. So I mean, it's sort of the same answer that I give to the planning board hypothetical. You could, a good lawyer on either side could probably make an argument either way.
With the ERA, is there sort of a time period which DEP should act, and if they don't, it's sort of, you can go in and enforce? Or I think you mentioned one of the cases was a 2-month delay. I know the agencies are giving great deference, but
yeah, I mean, unfortunately, we don't have a bright line, so we're left with a handful of cases that we can try to sort of distill some parameters from. And I think there's a spectrum, right? On one end, you have DEP just ignoring the situation completely. And on the other, you have DEP not ignoring, taking overt action, but maybe less than the full range of enforcement action that it could. And, different courts would perhaps deal with those situations differently. I mean, in the examples I gave, sort of illustrate that spectrum. And I think the statutory notice mechanism comes into play here too. The plaintiff is required to give the 30-day advance notice to the AG's office, to the DEP, to the municipality. And I think that's really designed to give DEP an opportunity to step in and do the right thing, and avoid, litigation, or, alternatively to intervene in the case itself once it's filed. So, no bright line, no specific period of days, beyond which you can say, all right, the courts have said now the lane is clear for me to go ahead with an ERA action. And I think, again, we're sort of left with the data points that we get from these cases. And as a lawyer, you can use those to sort of shape your case and use them for guidance. But, rule of thumb, the less action DEP has taken, probably the worse for the environment, the better for your ERA case.
very true. All right. If there are no other questions, we're going to thank you, Maggie, Will, Dan, and Chris. Greatly appreciate your expertise and time in this. I've learned stuff, which is always good. That's why I have these Technical Fridays, so I can learn stuff. Our next Technical Friday will be in September for everyone. We will have Clay Emerson from Princeton Hydro to talk about the permitting and engineering requirements to retrofit stormwater basins, how to fix basins that may have failed or ones that aren't doing as much as maybe they can with some additional upgrades. So that's going to be in September. It's most likely going to be on September 8th, because September 1st, I think, is the Friday before Labor Day. No one wants to do a webinar that day. So watch out for that information. We have sent out the verification form twice now for attorneys. If you're not an attorney, you do not need to complete the verification form. You can if you want, but you don't need to. So again, to our panelists, thank you very much. To our participants, thank you very much for taking your lunch and learning today. And I look forward to seeing everyone in September. Everyone have a great summer and have a good day.
Thanks, Mike. Thanks, everybody. Have a good weekend.
Thanks. Bye.
Thank you.
Bye.
Thanks. Bye.
Thank you.